Because your voice was breaking. That's why I could not hear you properly, actually.
So you can start.
Yes, ma'am. Thank you, ma'am. Good morning, all. Am I audible to you? Am I audible?
Yes, sir.
Yeah, thank you, ma'am. Good afternoon, all. And now let's move on to today's topic of liquidation 2.0 and winding up. And I think the participant is 17. Okay. Yeah. So I had an opportunity to address liquidation 2.2 last 2 weeks back. So now probably now little more developments are there, so we can discuss little more deeper than earlier session. So of course, like you, I'm also learning because this liquidation 2.0 is a new provision. As you all know that we are practicing right from last 8 to 9 years the insolvency code, almost 9 years. So now, but this amendment is very new, as you all know. It's about 2 months old. So you all know that IBBA has brought regulations also immediately on the amendments gets after amendments got notified. So very important changes. That's the reason I think the topic our institute also named it as 2.0 means that means it's a version 2 or episode 2, something like that we can take it in liquidation. Okay, very important amendments have come. So now let's today try to understand. I think last session it was very interactive. In fact, lot of inputs the participants have shared. Same way I shared my views also in the latest amendments. Today let's try to deliberate, try to understand the law better, so that we all go after 3 hours with a little more clarity. Uh, what we have as of now means this minute what we have. Let's have much more clarity when we close the session. So I request all of you to deliberate, because it's not like something I'm teaching the law or I'm sharing some my knowledge. It is all about new amendments which as a co-professionals we all see that we are understanding properly and practicing the profession of insolvency professional, whether as IRP or RP or liquidator, more effectively in tune with the provisions, the amended provisions, rather I should say. Okay, now moving on to our topic session. Before moving on to the, because I have more to share about liquidation, that to an amendment, I'll take you to provision by provision. So let's not miss any single amendment also. Let's see, try to see all important amendments today. Before moving on to the topic, liquidation 2.0, I was also requested to take care of the winding up portion a little, touch upon the winding up. Okay. So I know all friends, professional friends here would have handled both liquidation, also the winding up. I probably one or except a few, many would have handled both. I'm saying winding up and liquidation. So yeah, rather let's try to understand, or can I have your inputs? Either winding up and liquidation is totally different, or is one and the same? Is it totally different or one and the same? The process or the effect, net effect, all are one and the same, or it is totally different.
More or less
Any,
one and the same, sir.
more or less one and the same. Okay. And but law differs or same law?
But differ law. That is Companies Act, this is IBC.
Okay. That itself says that both have some difference. Correct? When law itself is changes, because why I'm saying this particular point, the object of Companies Act is different, the object of IBC law is different. You would have seen the object of insolvency bankruptcy code. The object completely, says that to revive the company. Okay, not even a liquidation. Liquidation is not the object at all. in the IBC code. Okay, and with respect to Companies Act, it is regulating the affairs of the company. Okay, so of course both are similar, not same. Both are similar process. That means the end is dissolution. That way we can say that both starts in a different direction, but ends with the dissolution and then meets in the same place, both liquidation and winding up. Why I wanted to first to take it this thing, because after I start liquidation, that one amendment after I start on the liquidation, I doubt whether I will get a time to share my idea in knowledge, little I know on winding up, I'm saying. Okay, I should not skip. When we start going into the deep into the liquidation amendments, then finally end of 3 hours, I should not miss out winding up. That's why now itself I touched upon little winding up. I want to touch upon little winding up. See, the whole IBC process itself, if you see the insolvency bankruptcy code, rather I should take you to directly to IBC code, which touching the amendment in the I think I should share only. But okay, before going into that difference, winding up in between little bit, I will touch upon wherever winding up and before that I will say the understanding of mine on the winding up and liquidation, and I'll take you through the provisions. When I take you to the BAR Act, that time I'll take you through the provisions where it touches winding up and where the provisions of liquidation. Let's try to touch both provisions in the law. See now, if you see the whole amendment, when the rather IBC code, I'm saying, let me come amendment little later. Let's deliberate on the IBC code per se. The Insolvency Bankruptcy Code 2016. Okay, when it get introduced, when you see the background and idea of the code itself, is that they want to separate it. You must be knowing it, but still I'm just refreshing your knowledge. You may be knowing and you would have done many liquidation, voluntary liquidation, winding up, both in the old act, new act, you must have done. But those who are not aware of it, I just want to brush up. Okay. If you see the time when the insolvency bankruptcy code has been introduced, that time the concept was very clear. The idea of bringing the code, I just take 5 minutes in explaining this because that's very important. Directly jumping into amendment, fine. But let's understand where it starts. The root, let's try to understand the root a little. Then we will move on to the other branches. Okay. Now, when you see when the IBC code was being introduced, the idea of the government was that. Okay. The idea of the government was that. The moment I use the phrase that was, that means originally the idea was that, but now what's happening? Things are evolving. Okay, let's discuss little later on that. The idea of the government was that to separate the creditors, issues, or addressing the creditors, rather I should say the financial failures of the companies, financial failures of the corporate. Okay, all financial failures of the corporate separately, to deal with that separately in terms of creditors due and in terms of creditors liability default. Now in making payment, they want to deal with the creditors separately. See, that's the reason. If you see, the whole concept of insolvency bankruptcy code has been brought in to make sure that the earlier the Companies Act, you all know that Section 433 we used to read in the 1956 Act. Section 4 to 30. Many a petition I filed. The time I'm saying some 10-15 years back. When we want to wind up the company for want of due, that time it was 1 lakh. And when I filed it in Section 433 of the Companies Act, 1956 I'm talking about. Not this Companies Act, because this Companies Act, all that Companies Act 2013 has got only 470 sections. That the Companies Act 1956 has got 628 Companies Act section. Okay, so in that section 433 of the 1956 Act, we used to file winding up. So from then onwards, the same thing was followed till 2013, till introduction of the insolvency banks. See, why the reason I wanted to tell the root of it, let's try to understand why both are seen different, not the same. Because the evolution of the winding up is age old. The evolution of the insolvency code, you all know that we started doing from 2016 onwards. Okay, so both are a little different with respect to the process. Even I should say in a legal status also, rather little with respect to the legal status also, both are little not same. Just like that, we can't say that liquidation and knowing one and the same. No, both have some difference. Okay, why that difference they want to bring? The government wanted to bring by introducing IBC law. That only we need to understand. See, earlier the winding up provision, as I was telling you, Section 433 1956 Act, there after introduction of the Companies Act 2013, then the whole thing has been, the corresponding provision has been reproduced, Section 272, 271, 272, 273, 274. All that's the same thing, 433, 434, 435. Same thing has come 271, 272. So this was how the things, winding up has been evolved. The provisions has been evolved. So after a period of introduction of the IBC, means in the year 2016, once the introduction of the Insolvency Bankruptcy Code, the idea of the government, okay, the note on classes that time they introduced, they kept on telling while introducing the IBC code that they want to make it creditors winding up separately. That means they want to deal with the winding up under Companies Act, which is not a financial failure. That is the idea. That's the idea why they brought IBC, the code itself, because they want to address the entire financial failures. You all know that Insolvency Bankruptcy Code, when it is introduced, is subsumed Provincial Insolvency Act and Presidential Insolvency Act. Both are central act. Okay, they subsumed the whole thing, and BAFR also is subsumed. In same way, certain provisions of the Companies Act also has been altered. That's the reason we got the 11th schedule. You all know that. That's the 11th schedule separately was introduced under the Insolvency Bankruptcy Code, completely altering the provisions of the Companies Act. In fact, the time when it was introduced in the year, right from 2016, the time, those days in the year 2016, 17 and 18, when I keep addressing on IBC code, the main point I keep telling same only. Probably now the participants are different, so I thought I can share it. So the idea of why they have to bring it the code, why it is not act, I kept on telling in those days that the why schedule 1 to schedule 11 is being introduced, inserted in the Insolvency Bankruptcy Code. The reason being that why it is introduced a code. If it is an act, it can't override another act. If it is an act, because the act has got same legal force. Every act has got same legal force because every act is passing through same legislative process. So it cannot simply override unless it has got a special power to override it. That's the reason we have earlier Indian Penal Code. Now you know BNS, BNSS and all that. Earlier we used to have an Indian Penal Code and Criminal Procedure Code and Civil Procedure Code. It was the entire guiding force of the criminal laws for Criminal Procedure Code and civil laws, Civil Procedure Code, because it's the guiding force. Okay, for the entire civil laws of the country, same way entire criminal laws of the country. Same way government want to bring the code for entire financial field. That's the reason they brought the insolvency code. So that's the reason they also separated very clearly that creditors, default, liability, dues, loan related alone into the IBC, so that they want to address the financial failures of the corporate in the country by bringing the Insolvency Bankruptcy Code. So this is the main difference that we need to understand. I will show you when I'm taking you through Companies Act 2013. I will show you the section 271. Then you will understand the fine difference, how they brought the introduction in the section 271 of the 2013 Act, where they would have removed only the unable to pay debt by creditor. That alone they removed in 271 and they brought under Insolvency Bankruptcy Code. Okay, even you know that the amendment made in section 271 That only took shape of section 7, 8, and 10 in the Insolvency Bankruptcy Code. Same way, you all know that voluntary winding up earlier we used to do. Now it got inculcated into IBCS section 59 as a voluntary liquidation. You all know that. So I'll take you through when Companies Act, when I touch the 2013 Act, I'll take you through section 271 and will show you the difference, exactly how what is written in 271 is nothing but when ROC, when central government felt it is just an equity to initiate a winding up, then it can be, the winding up can be done. Same way, as you all know that the winding up process can be done even by passing a solution. Very simple. You all must be practicing, RP or IRP or liquidator. You must be knowing when there is a default. The company, without going into CRP process, they want to wind up, they can come under Companies Act. Without following CRP process, they want to wind up. When there's a default, okay, then they can come under the company and go into the court process for winding up. When there is no default, they can prove the solvency, but they want to liquidate the company voluntarily, then they can very well go into the section 59 of the Insolvency Bankruptcy Code. So with the CRP process, they can come under section 10. Without CRP process, they can come under the Companies Act in winding up. This is all about a simple note on the winding up. Okay, winding up itself is a kind of a ocean. When it was in 1956 Act, the winding up itself, we always say that the entire Companies Act in 1956, I'm saying 20 years back, we used to always give comments that no, in Companies Act, entire Companies Act, if you segregate 628 sections of 1956 Act, we can segregate winding up. There's the equivalent provisions of 300 odd sections is allocated to the winding up, and equivalent 300 sections allocated for other matters other than winding up. That means the winding up was literally carrying half of the bad act of the 1956 Act. That level, winding up was given importance. The provisions was given importance. That's the reason government thought, okay, let's make it a separate law and make it simple process and make it a clear process and time effective process. That's the reason we brought the Insolvency Bankruptcy Code today, what we are going to discuss about. So this is the basic difference which I wanted to tell on winding up and liquidation. If you have any point on that, on anything to share, you can share, or otherwise I'll move on IBC amendments. Anything to share on winding up and liquidation? The difference or anything on winding up, you can ask me or share any information. Otherwise, I'll move on next to the winding up. Can we move on to liquidation amendments? Okay. I will again touch upon winding up wherever I am able to touch, or wherever the connected provision has come, I will touch upon that. Okay, fine. Now coming to the amendments. Now in you all know that how many amendments have come so far? You must be knowing the amendments in first amendment in 23/11/2017. Okay, okay, and that amendment, if you see, in fact, it is very easy to recollect. Rather, I should say, it is very easy to recollect. The first amendment, it came into 23/11/2017. Okay, classified personal guarantor, like the corporate data as a separate category, and preventing undesirable person from taking over under section 29A. In fact, 2017 amendment mainly for 29A. That was the first amendment. What is the second amendment? The second amendment on 6/6/2018, but 6th June 2018. It touches upon the home buyers. In fact, home buyers provisions first time introduced. Home buyers made as a financial creditor. You must be knowing that, home buyers have been made as a financial creditors. And next, the voting threshold from 75% to 66% has been brought down. Earlier, it was 75%. After the second amendment, they brought 75% into 66%. Same way, they permitted withdrawal of corporate CRP process by 90% or more voting of the committee of creditors. You know that section 12A has been introduced in the second amendment. Same way that the guarantor was included from the moratorium. These are the important things. In fact, they relaxed the 29A applicability to MSME. I'm saying all this is in second amendment in 6th June 2018. I'm saying. Same way, 240A also opened window for specific regime, means they opened up MSME 240A. These all second amendment they covered. Then they brought third amendment. Third amendment in 16 August it came. 16 August 2019 it came. The main amendment in 2019 is mandatory completion in 330 days, including all litigations. They brought in 16th August 2019 in the form of third amendment. Then the distribution of resolution, all that, how to distribute, all that they brought. Same way in different classes of creditors present and how voting should be done. All this is brought in the third amendment. And even resolution, the effect of resolution plan, how it binds once it is approved. Very important amendment that has been brought in third amendment in, as I was telling, 16th August 2019. Okay. Then fourth amendment. Fourth amendment 28/12/2019. That they brought a special privilege, like termination should not be done, and licensing, all that, how it should be done in case of a resolution plan approval of immunity given to the corporator for all whatever the misdeeds or whatever it is under 32A I'm talking about. All this important amendment came in fourth amendment with effect from 28/12/2019. I'm telling this fourth amendment. Then fifth amendment came. Fifth amendment is nothing but like suspension due to COVID. You all know that because of the COVID, the whole country has gone into a lockdown of 5 months to 6 months. So on 5th June 2020, they brought that COVID related notification. Then sixth amendment came. Sixth amendment, not much changes are brought in. They brought only this pre-pack. They brought in pre-pack related insolvency process, pre-pack insolvency part. That was the sixth amendment. Then only they introduced the seventh amendment, which we are discussing now. Now, seventh amendment has got a lot of, rather we should say that this 2.0. I think so far the sixth amendment, we never called it 2.0. Why the seventh amendment alone we call it 2.0? Any point on that? Because members are silent. Should not happen, participants are sleeping when I am talking. Look, should not look like that with my rhythm of talk they are sleeping. Anybody, is there that share why it is called 2.0? Why not six amendments is not called 2.0? Why seventh amendment alone called 2.0? Any comment on that? That level amendments is big, or that's the only reason? The amendments are, many amendments are there. That's the only reason, or it changes the entire IBC code. Any inputs? You can share anything. Here we are here to deliberate the new amendments. Almost how many? 20 is there. My God. All 20 is keeping quiet. Come on. Let's have a, why this particular amendment assumes lot of importance. Lot of importance comparing to all six amendments. Yeah. Yeah,
Sir,
please.
it's primarily because a lot of major amendments have happened. I mean, earlier I feel that most of the amendments were more to do with the judgments coming and those being incorporated, but or rather, the case laws just being what they are. But in this, they have been like 29A was one of the major milestone. So this is like similar to 29A being added, and then a lot more than that. I mean, a lot of structural changes have happened, sort of in. the recent amendments?
All these amendments are really required, or it's welcoming, or much thought amendment, or something surprise or shock? Is it a surprise or shock, or is it welcoming amendment? What do you feel?
I think some of them are required actually.
Okay. Not all. Not all.
I'm really new to the ecosystem, so I won't be able to comment much.
No, our friends must be knowing by now. Who are in active practice by now, they may be knowing now. Okay, whether it is welcoming or not, or what way it is going to impact, how it is impacting. Already it would have started impacting. So that's why reason I am asking our IP friends to share their views, so that it should not be like I'm dumping my points here and leaving. No, I don't want to do that. That's not the purpose of the session also. Here the session is to deliberate, so that with our deliberation, if something meaningfully we could able to give points, at least the regulators can look into that. We can take it as an opportunity for the to highlight to the regulators what needs to be addressed, what is over addressed, what is not addressed fully. All that we can escalate and highlight. What do you feel? Am I right or wrong? Is there anything like that? Or is it okay and it is very much look at our one of our friends said, in fact, without knowing much of ecosystem, he was deliberating, but many of our friends looks like their names are practicing friends are there. Then why you are not sharing your knowledge, your experiences, and what do you feel on this amendment? I'll take you through amendment. I'll share my views. Don't worry. I have many to share, lot more to share. But before that, I thought I can hear from you. Before injecting my views in you, I thought I can take inputs from you, so that it should not happen. I am biasing you, and because of that, your views are changed. No, I don't want your view before my inputs goes in your mind. Any views on the amendment? Is it really required? All are really required? Is it welcoming? It will really improve the way how IBC working in the country, in terms of economy, in terms of compliance and other aspects, improving economy. Will it have a more effective, or rather I should put, will it be more effective with this amendment? What do you feel? You have no idea. So you are ready to completely go into the ambit of the amended IBC. Okay, so you all prepared to work like a court-appointed bank officer. Your silence only showing the acceptance that we are all ready to work like a court-appointed bank officer. In Sarfasi, bank appoint authorized officer. Now, after this amendment, the corporate is going to be like the liquidator will be like looks like a court-appointed bank officer. Is it not? Do you have any contrary view, or you agree? You can say that, no? You agree. After this amendment, the liquidator is going to be a court-appointed bank officers, or still court-appointed officers? Yeah, you can share your views. Who is this? No. Okay. Okay, fine. That means you're all agreed. Yes, let's be a court-appointed bank officer. Okay, we'll move on. Okay. Wherever little bit, we can improve our effective practice as liquidator, we will try to improve subject to the amendment whatever brought in, and of course subject to the approval of COC in all matters, whatever liquidator going to do. Okay, let's all be ready to see that that we take blessings of COC in each and everything before doing liquidation. I don't know. Then as liquidator, going forward, what liquidator on his own will be taking decision. I don't know, because now looks like everything left to the hands of the COC. So that's why I was saying deliberating that court appointed bank officer. That's why I said. Anything to offer?
Yeah.
Yeah, tell
So
me.
just recalling from one of the earlier sessions with Dr. Ashish Pitija, this is what exactly I mentioned, that the RP's discretionary ambit earlier has sort of been now curtailed, not curtailed, but it's limited to a lot of approvals from COC. Am I correct in my understanding, sir?
No, there's no question of curtailing. See, first of all, let's
Okay.
understand. There's no question of curtailing.
Yeah, I take back the word curtailing, but it's like it's sort of now much more dependent on COC approvals. Like if for everything, RP has to now mandatorily take a COC.
But I will tell you in a very
Yeah,
simple
yeah,
thing. I'll tell you. Okay,
yeah,
I'm not blaming anything, or
yeah,
I'm not criticizing. I'm not.
yeah,
Neither I'm appreciating nor I'm criticizing. Please note my point
yes,
here.
sir.
All I'm
Yeah,
sharing is just a view. Okay, by reading that, no, as a speaker, as a IP, what I felt, I'm just sharing. Okay, see the idea of bringing the, I'll take you through every amendment. Don't worry. Don't think that I will close the session by talking like that. Okay. I have a point. Every section I will take you. Okay. Next 2.5 hours, just give to me. I will take you to every amendment and make you to, let's try to understand. And whatever we could able to understand, we'll try to understand. See, the idea of why the IBC code and why the fraternity called IPS given birth, right? Is that the earlier there is a law called the Prevention Insolvency Act that didn't prove. Presidential Insolvency Act that also didn't give result. The Companies Act winding up that also didn't give result because 20 years and all it was sleeping. The cases were sleeping. Okay, 20 years, 30 years and all cases were sleeping. Nothing was happening in winding up cases and under Companies Act 1953. I'm saying. And then Sarfasi also things have got prolonged like anything. Sarfasi also. Then government thought, okay, let's address as I was giving a introductory note. Government thought that let's have a law which give one point solution without intervention of anyone and time bound. See, that's the idea. Time bound solution without intervention. That is that to court supervision. Court supervision is very important aspects here. Court supervision, time-bound process, the government wanted to introduce. That's the reason they brought the IBC code. If everything can be given to the bankers, and nothing wrong. Nothing wrong. Very well, because they are the stakeholders. After all, they are the stakeholders and beneficiary of entire thing. They only lend the money, no doubt at all. But here the question here is that why a special category, a trained, well-trained category of IP who has to simply listen to COC and do, then why he has to be trained that level just to listen some committee? Because there 10, if assuming 10 members are there in the committee, 10 different view will come. Of course, there's a 66% decision, all that is there. The moment we leave it to the decision of the gathering, meeting, always it drags, right? And multiplication of litigation cases, that only even many cases of last 8 years, last 7 years, IBC is not closed. Still matters prolonging. The reason being that so many cases are getting filed by stakeholders, promoters, bankers, and every side. Now, all the more now, uh, uh, what happened now? We are giving the decision to stakeholder. Then what I see here, um, less scope is given, opportunity is given, IP to uh, think unique way, apply his mind and unique way, again give resolution or find out the method to maximization, because the bankers always they think that okay, let me get my money. Always bank, because they want their money back. They need not to wait. No bank will accept to wait also. So they always want to take money back and go and focus on next one. Nah? So here, this law has been brought in to, even if you see that the object of the code itself says that asset maximization. Then for asset maximization, then it has to be a proper, principle has to be followed, formula has to be followed, and due process has to be followed. And it takes little time also sometime. And sometimes it may go against the desires of the stakeholders, few stakeholders, not everyone. Then immediately the few stakeholders will go and jump the court and they will file. They use the section 60 of the IBC code and file cases, then get started. So the idea here is to reduce the timeline only, they reduce the number of people here, intervention of the people. That only I wanted to tell you, convey here before commencing my session amendment. I wanted to say the purpose of bringing the IBC code itself, reducing the intervention of person. But again, now we are going back, bringing more intervention. Very simple. The intervention may be good or bad. We don't know. Only we have to wait and see. By giving, but the purpose of object of IBC originally is to reduce the intervention. It should be between the court and liquidator to deal with the liquidation process, so that anything is a liquidator to take direction of the court. That's why reason you all see, you all know that section 35 clearly gives out to say that subject to the direction of the Honorable Adjudicating Authority, the liquidator shall allow following powers. It is not giving open-ended powers to the liquidator to do all what is provided under 35. It says very specifically subject to the power of the adjudicating authority. The idea is that reducing intervention of other people, whoever it is. They may be the owner, they may be the promoter, they may be the stakeholder, they may be person who aggrieved or deprived, whoever it may be. But the moment it comes into the liquidation process, to get a time-bound resolution at a maximum value, then intervention should be less. That's the reason they narrowed down to court, means LCLT, adjudicating authority. And they narrowed down the role and brought on a new role, a professional called insolvency profession, who has to act only under direction and supervision of the NCLT. Now bringing this amendment, now much more intervention has come. So now we have to wait and see how it works. So, but the idea of the court may get diluted. That's my personal view. What I could guess from that, the more intervention delays the process. Generally, there's a logic. When we involve more people, it delays the process naturally. Correct? So now probably further it delay may process, that only is a question, because now more intervention is there. It's not between the court and court officer earlier, where court can take decision and tell Mr. X, do this, do that. The court will give direction to the liquidator will execute it. Okay, and file a report to the court that yes, as ordered by your lordship, I've done everything. That's what things are happening. So things are moving at least little faster. Now going back to the larger numbers for approval permission, will it happen the same speed what it was happening? That we have to wait and see. That's the whole thing which I wanted. In fact, this is the I won't say this will happen. I'm saying probably this may or may not delay, or may not have impact. So we have to wait and see after because it's only 2 months old, the amendment. Okay. Now, any points in amendment, or I will move on with the sharing what are the amendments, what are the changes introduced, so that we will move on to one by one. Okay, I will move on to one by one. So enough, I deliberated. Now, I know how the government department keep telling our hands are tied up. Something they are not able to do, give relief. Immediately the government and authorities will say our hands are tied up. Like that now, liquidator hands are tied up. They have to follow the norms. So they correct. They want to follow the norms. At the same time, they can also tell the regulators that what are the difficulties that they may face, because we have a practical experience as liquidator. I'm saying more than anybody else, as liquidator, as RP or IRP, we have a more what to say, practical experience, and when we handle things, we have encountered difficulties. All that we can only able to appreciate, or we can only able to escalate and tell others whoever it is. Okay, so that's the reason even the institute is giving opportunity to us to deliberate and come out with the uh, our points, our inputs. Okay, now I before moving on to the liquidation, just to touch upon the amendment, though liquidation only is given to me, but say I thought before starting the liquidation, I thought uh, third amendment regulation of CRP and fourth amendment regulation of CRP. Of course, you all know that third amendment regulation of CRP regulation means IBBA corporate insolvency resolution process for corporate person, 2016. Third amendment, which came into effect from 1st June 2026. Same way, the fourth amendment 2026 also, which came into effect from 8th June 2026. What are that? Why I am talking about CRP? Because few amendments in the liquidation process that little almost similar to the CRP amendments, and also certain things little connected to the CRP amendments. That's the reason I thought I can little brief on CRP amendment also before going into the liquidation amendment. What that CRP amendment? Very simply, quickly I'll move on to CRP amendment, third amendment. It talks about section 9, what information to be furnished by the operation creditor. You all know that regulation 2B has been substituted, and I'm talking about the CARP third amendment regulation, which came into effect from 1st June 2026. Okay. Now it touched upon regulation 2B, information to be provided by the operation creditor, which is section 9 application. What is that? Regulation 2B has been substituted to prescribe consolidated list of information that an OC must furnish. What are the consolidation information? Copies of GSTR 1, the 3B, and all that should be given. Partial payment, if anything is it, that has to be given. Details of assignment and transfer of operation debt, that are details has to be given. Guarantee details has to be given. Then whatever the principal and interest, that has to be given. So like this, now the little more information has to be given in addition to the earlier information whatever given. That was the introduction to B. Same way 2E also has been introduced. What 2E is nothing but same way how I told 2B. 2E is that information to be permitted by corporate applicant under section 10. Same way only, but here additionally what they are trying to say, give further document, is that list of all bank accounts and particulars of assets, movable assets, immovable inventory, investments, like that, intangible of assets, even IP rights, whatever IP rights, even virtual digital assets rights, all that receivables, whatever, all that now we have to give along with the section 10. Same way, details of secured, unsecured. These are the additional information that we have to give while filing this application under section 10. Even ongoing litigation, even subsidiary, JV, associate companies, and corporate guarantees, related party transactions that we have to give, regulatory approvals, license, registrations, and statutory compliances, and if any JDA agreement, joint development agreement, and even more particularly asset under attachment by enforcement agency and all, we have to give. Earlier that was not the requirement. Okay, now after the court inquiries only, the parties used to give the details. Now they wanted all these details to be part of the section 10 application if assets is under attachment by enforcement agency. Same way, demand notices, assessment orders, recovery proceedings, all that should be part of it. Suppose if any proceeding under PMLA Act or a Binami Act or FEMA or Companies Act, any criminal proceeding, investigation, all these details should be given. Earlier, there was not a requirement, there was no requirement to give all these details. We had a certain attachment has to be given, that alone we used to file along with section 10. But now we have to file all detail of all alerties, all that we have to file. That was all about regulation 2E. Same way regulation 3 also amended, whereby intimating IRP to RP on okay. What that it says that regulation 3, subregulation 1A has been introduced. That means regulation sub 1A has been omitted, and instead of 1A of subregulation, 2 new regulation has been inserted. 3.1A and 3.1B in regulation 3 of what it says. It says that if by the by the committee of creditors, if in the first meeting, if they resolve to appoint a IRP as a RP, then IRP must intimate the decision of CD, okay, to the decision to the CD board and adjudicating within 3 days. So now this requirement has been introduced. Okay, they become the IRP duty now. Same way, where the COC decides to replace IRP under section 22 or RP under section 27, it will take from the proposed RP written consent. You know that consent also has been introduced by IBPA by circular. In fact, I will show you the circular also. Now, what next in I'm saying CRP regulation? Same way, if you see the duty to extend the cooperation, what is in section 19. Now they include any person covered under section 19. In fact, if you see regulation 3A is been reframed, duty to extend assistance and cooperation. Instead of word personal, okay, the personal word of the I'll show you in the even in the Amendment Act. I'll show you this. Okay, how it got replaced. When we see section 19, I'll show you. So replaced as any person covered under section 19. So that means section 19 scope is enlarged. So that CRP amendment covers. I'll show you in the Amendment Act. Then we will understand better. Same way regulation 4 also, it's substituted. Regulation 4 and I'll show you even regulation 13 also. I'm saying information from creditor and the first COC. In fact, regulation 4 has been substituted. They have to RP, and very important amendment. That's why I wanted to touch upon the CRP. The IRP and the RP, they may seek wide range of information from creditor now. In the first COC meeting itself, whatever the detail from that they can take from the creditor, they can insist in the first COC itself, like valuation report, stock statement, receivable statement, inspection report, audit report. Earlier, RP and IRP is not given this power. Now the IRP, they can take details, they can insist for details from any creditor to give all these details. Receivable statement, stock statement, valuation reports, and stock audit report, search report, like that, bank statement, and even what are the information that may need for the information memorandum to prepare. Earlier, this power was not given. Same way, a provision was required where every creditor to furnish at the first COC itself all the information. So very, very important. I think first time the obligation is given to the COC to give information. The first time I'm seeing in the regulation. The COC is given an obligation to give information, whatever sought by IRP, RP in the first COC meeting itself. It's very important changes that has been brought in. Same way 4A, regulation 4A, 6, 7, 8, 8A, 9, 9A, 16A, 36A, 39, 4, all that has been now has been touched upon in the Manbar, whereby the forms have been introduced. Same way, transfer of guarantor assets in the possession of creditor. This is very important. See, this, why I'm showing this, because all these provision will come under the Amendment Act. When I'm showing the Amendment Act, there you will be showing the respective corresponding amendment in the Amendment Act and Amendment Act 2026 of the ABC. So that I will show you all that. Okay, transfer of guarantor assets in the possession of creditor. How now a new provision has been enabled, whereby if a creditor of the corporate debtor, okay, whether before or after CRP, if they have taken already possession of the asset, okay, I'm saying the creditor already they have taken a possession, even maybe before CRP commencement or after during CRP commencement, okay. So if they taken the possession of asset, a personal guarantor, okay, or a corporate debtor, then association profession may place a proposal to them to allow to transfer such assets as part of the resolution. The resolution profession may place request. Now they can say that why don't you bring that assets also into this resolution thing, so that a consolidated decision can be taken. I will discuss in detail when the Amendment Act, when I show to you. The regulation 2B, same way facilitation, how it is to be done, all that is there. Same way regulation 12A, which I also little touched upon. I'll show you what is the amendment brought in the Amendment Act. The corresponding 12A, the corresponding regulation substituted is regulation 30A to section 12A of the Amendment Act, whereby they said that within 3 days of COC approval, whatever this should accompanied by the bank draft and demand draft. Now they are making it very specific. Earlier, just by giving a form, now it is not possible. You also give a company that also should attach bank guarantee or DD for the purpose of 12A for settlement. Same way, information memorandum, regulation 36, 39. Okay, how it is to be done. Resolution from one of the plans must provide for resolution as a going. Suppose is regulation 39 3D, what it mandates that where there are multiple resolutions from one of the provision may provide for going concern. So not all that. One may provide. Now regulation 39 4 is amended to give instruction to the RP to submit COC approved resolution plan to the AA within 30 days. Earlier it was 15 days, now 30 days. Okay. Now model timeline also recalibrated, and resolution of CD during CRP, recall of CRP, all this is there. We will discuss in the dissolution of CD during CRP and how it can be recalled. The corresponding provision when we see in the Amendment Act, in the CRP regulation, regulation 40E and regulation 40F has been introduced. Suppose the dissolution during CRP itself, the COC is taking a decision by way of voting by 66% voting share. Regulation 40E is enabling it, means that gives power to COC during CRP itself to take a decision for dissolution. Same way, regulation 40F enables to recall CRP itself. CRP itself they can recall when it is before passing in a liquidation order by adjudicating authority. These are all literally a very welcoming thing, because they want to see that again to rework. Just because of once it is failed, it's not they want. That's what I started the session by saying the object of the insolvency code is not that liquidation. You can't see the language context called liquidation in the object of the code at all. In the preamble, you can't see that at all. The reason being the idea of IBC code itself is revival with less intervention. That's because the RP should be a one point contact, of course, with supervision of the COC, no doubt, and he has to make sure company is revived. So that was the intention. All these so far I told what's deliberating was third amendment, and fourth amendment was carrying very few changes only, like COC composition, unrelated means how it should be. The word unrelated has been inserted now in the COC constitution by way of a fourth amendment. Okay. Same way observer seat where non-bank, all that 66 amendment. I will take you through when IBC Amendment Act, no, I will take you through. But corresponding changes, whatever brought in CRP regulation, I'm just sharing here. Regulation 31B has been touched, whereby COC approval of the CRP cost and new going concern, assessment report and all has been cost approval. Now many things have introduced, whereby 31B, regulation 31B, one has been introduced, whereby CRP cost incurred till for COC together with justification all should be placed before COC approval. Same way 31B2, RP must prepare going concern assessment report covering estimated income, expenditure, cash flow and working capital requirement. And 31B3 has been introduced, whereby COC shall decide whether operation CD to be continued or not, and what is the scope and duration and all that they can decide. 31B4, in fact, after first COC meeting, whether CRP cost shall be incurred only with the prior approval, all how it is to be incurred, that decision can be taken. It provides for in 31B new provision. For 31B5, 5, class 5, that even it says that RP should place income and expense cash flow statement, everything up to there for the period after the meeting or next meeting. So what and all the RP should place before the COC, all that now clearly put in. Now that clarity was not there. Now the clarity has been brought in. So these are the things which really made it very, more what to say that changes, means which has been brought by way of an amendment by Amendment Act 2026 and corresponding a third and fourth amendment of CRP regulation. In fact, COC even should record the deliberation also rational on the resolution plan. Now new class B has been substituted. Now COC has to record its deliberation rational, whether feasibility, viability, and what is the expected realizable value. All that now is a new requirement. So these are the CRP related thing that we need to understand what and all in third amendment, what and all in fourth amendment. Now let's move on to the liquidation. I thought before going into the liquidation, without touching upon important points on CRP, I thought it won't look nice. So I thought, okay, let me touch upon the CRP amendment, because all that we are going to deliberate in the Amendment Act. When we see the Amendment Act, all this will be deliberated by us. So if any doubt, I'll take. Otherwise, I'll move on to liquidation portion. We'll move on to liquidation portion. Or if any doubt on the CRP or till now whatever deliberated, you can share your views. Otherwise, I'll move on to liquidation. Okay. Shall I share my screen? I will share my screen and just a moment. I'll take you through liquidation now. We are now restricted to liquidation, and if anything on the what we deliberated for last 1 hour, if you can, I will share now. Just a moment. Yeah, you are able to see my window. Oh, not this. This has got a lot of changes. Okay, now let's come to the changes of the Amendment Act. Then we will move on to IBC regulations. Okay, what are the changes? What I've done is in Word, I've made the changes. In the core, I'm saying Barrack. In the Barrack, I made the changes. Okay, so that it is easy for us to appreciate the changes what has come. And we will also, need be, I will also take you to Amendment Act wherever is required. Yeah, this is the code with effect from 26/5/2026. I will take you through to amendments now. Let's deliberate. Wherever you want to stop me and discuss, you can stop me. Yeah. This is on the code. Okay. See, I have not prepared a PPT exclusively for this purpose. Other amendments and all I prepared PPT, but for this it's too early to prepare PPT because I don't want to restrict. Now, not things are not settled now. Means we have to literally wait and see that any clarity has to come or any how the process going to settle. All that we have to see. Now, better to go into the language of the amendment itself. Then only it will be easy for us to interpret and understand, so that see everyone have a different view. When we read something, we'll have a different view. Once we practice and settle, then probably we can narrow down to that and bring it in the form of a presentation and say that this is what it is and how the practice is settled. All that we can, well, it will take little more time, but that's too early now. We are, as I was referring, that it's only amendments are only 2 months old. So let's see the language what is used and let's try to understand and let's try to have a deliberation and try to, yeah, now this is 27 years registered valuer. Yeah, now very important amendment 31. I'll do one thing. Rather, I'm taking you like this. I will take you to the code. I'll show you there. Then I will show you this word. This is bold. So this is the amendment. Okay. Now, if you see this, I'll come you. I'll take you to here. So what is that? First register value. Okay. Now the explanation has been given. This only I was showing here. Okay. If I only show this particular amendment act piece of this page alone, you may not connect. You may not get connected to which provision exactly it is. So that's the reason I am taking you to section. Okay, what it's so that in the form of different color so that you can easily understand what is the earlier one and now how it is appear after amendment, how it appears. The earlier one, this security interest, right? No. See, the earlier one is this. The changes that has been brought in is this. What is that? The changes has been brought in. As I was referring, for removal of doubt, it is hereby clarified. But the security interest shall exist only if it creates right title or interest. You all know that rainbow case. To put rest to the confusion or whatever we say or interpretation. Of course, subsequently in Panchami case, it has been clarified by same Honorable Supreme Court that the rainbow judgment will fit into that particular fact. So, and they said when fact differs, and also the judgment clear, subsequent judgment of Honorable Supreme Court says that the justice who passed the judgment of the rainbow, Honorable Justice, did not have occasion to see that section 53. All that's the judgment it is given. So that's the reason they said that the statute have a specific power that giving a security means interest for any tax due. So that's what the then they should be treated as secure creditor. That's what the findings of the that was the judgment of the rainbow to what to say, to clarify the position more clearly or to give more clarity. They brought in the form of amendment itself, whereby they removed the doubts. That's why they said for removal of doubts. It's kind of a clarificatory amendment. Rather, that's the reason we call this generally we call as a clarificatory amendment. Okay, there will be amendment to introduce new provisions, but here this amendment is a clarificatory in nature. For removal of amendments, for removal of doubts, it is hereby clarified that the security interest shall exist only if it creates right, title, interest, or a claim to a property pursuant to an agreement or arrangement by the act of two or more parties, and shall not include security interest created merely by operation of any law. This is very important. Here, this very important thing is they want to clarify this particular point that it shall not include a security interest created merely by operation. That means just because a statute says, okay, that it carries security interest, that it will not. It should also have that should exist. No? That some right, title, interest, or claim to a property pursuant to an agreement. That means an act of party should be there. It cannot be by violation of law alone. That's the point here. The security interest should not get created by violation of law alone. There should be a right of parties. Means act of parties also should be there. That's the reason they said it creates right, title, interest, or claim to a property pursuant to an agreement or arrangement by an act of two or more parties. So by act of parties, we call it by act of parties and violation of law. So here by act of parties. Okay. So now they made it clear that just because of one act, whether it is a Gujarat Sales Act or any other act for this matter, just because of it says that any tax due, it will have a security interest, it will not have a security interest. There should be agreement for that. That's the law says today. That means it comes back to the provisions of Companies Act. Very simple. For creation of charge, this is the parameter. So they bring that particular provision only. They are bringing it back to create charge, means security interest. Service provider. Now this particular thing also is very new. Where the other I should say here, if you see, it has been inserted. It is very important. Okay, it is inserted. Service provider definition now has been inserted. Oh, this why it is not coming. Anyway, fine. I'll show you that. 31A service provider means a insolvency. I'll show you in my word. You'll have better. Yeah. Service provider means an insolvency professional agency. So all this, why they brought the concept of service provider, I'll show you when we go into the, when we move forward, I'll show you the purpose why they brought service provider. Okay. They now said service provider means, it is not inclusive. It means an IP, IPA, information utility, and register value, or any person falling within the category of person, if it is notified by the central government for rendering service in relation to insolvency bankruptcy process and is registered with board. It's very important. Okay. So I'll discuss with when we move on what is the relevance of introducing service provider. Now coming to next amendment. Now avoidance transaction, we always earlier we call it avoidance transaction. Now they brought even a definition itself whereby they said avoidance transaction means transaction. See, if you see here, they brought now avoidance transaction means it was this only I was telling. Avoidance transaction means a transaction bigger. Yeah. So avoidance transaction means a transaction as referred to in section 43. Okay. So now all this will come under purview of the avoidance transaction. 43, 45, 49, 50. Okay. Now going into next amendment. I'll take you here. Next amendment. Now 9A has been introduced. This is very important. They brought a definition for fraudulent and wrongful trading also. What is an fraudulent? Because if you see section 66, it uses the word fraudulent and wrongful trading. Okay, that's why they wanted to have a definition for that. It means the fraudulent wrongful trading as referred in section 6. Because wherever the word fraudulent and wrongful trading, they now connected that phrase, that context, to section 66. That means it falls squarely within the purview of the section 66, wherever the word fraudulent or wrongful trading. Okay. Now coming to next amendment. Now the proviso has been introduced. What is that proviso? Now, provided that where multiple applications for initiation of CRP in respect of corporate are pending before AA, and the initiation date shall be the date on which first such application was made before. So it's very important. Suppose too many applications are there. See here, class 11. Okay. The first provision has been inserted. What? Provided that where multiple application for initiation of respect of has been pending on date terms of it, the initiation, what is the initiation date? Shall be the date on which first application was made before adjudicating authority. So there should not be any confusion when multiple application is filed. Now coming to next amendment. what is done under Act. I'm taking through Act. After this, I'll taking through regulations. Let's not skip. That's the reason I'm moving it very slowly. So now coming to this explanation. Very importantly, if you see merger amalgamation, all you know that earlier under the definition of resolution plan, it was simply the resolution plan was including was covering, rather I should say, the resolution plan was covering means a plan proposed by a resolution applicant for insolvency resolution of corporate debtor as a going concern in accordance with part 4. That's all. There was no scope for earlier, I'm saying, before the word merger, amalgamation, demerger was introduced. Earlier, it was only the intention was to move on as a going concern, means there should be a provision for going concern. After the word merger has been introduced in the amendment, you see, Insolvency Bankruptcy second amendment, 66/2018. Okay, the word merger, amalgamation, demerger has been introduced. Now, along with the word merger, amalgamation, demerger, by virtue of Amendment Act 2026, now the word of sale of one or more assets of corporate debtor through one or more plans proposed by one or more resolution applicants is wide now. My God. Now they gave a lot of liberty now. Earlier it was totally different. See, for the words merger, amalgamation, demerger, only this was included earlier in the resolution plan. Now, along with this, now if you see, this is replaced or substituted with merger, amalgamation, and you see that Alex. No, let's not do this now. See, merger, amalgamation, demerger. Now, along with this, the sale of one or more assets of corporate debtor through one or more plans. So that means now plan can provide for selling one assets or one or more assets, okay, through one or more plans. So there can be different plans proposed by one or more resolution applicants. That means there can be a multiple plan by multiple applicant, and there can be multiple, a plan for sale of one or multiple assets. Need not to be one plan which covers everything. No, that need not to be. Now they introduced that means they expanded the scope of giving the resolution plan. The plan now it can be anything. Almost it sounds that way, that it can be anything. It can provide for sale of one or more assets by one or more person, by one or more plan, merger, amalgamation, demerger. In fact, rather I should say merger, amalgamation, demerger itself, I would say that anything under Companies Act can be done under merger, amalgamation. Because as a CS, we know that what and all can be done. We are doing also. Because amalgamation, merger, 230, section 230, I'm saying earlier Companies Act 1956, right from section 390 to 395. And it provided enormous scope under 1956 Act, 390 to 395. Now corresponding section 232, 235 of Companies Act. Now that also provides enormous scope to provide for, because it provides for compromise, arrangement, and whatnot, merger, amalgamation, demerger, and any scheme can be proposed within the parameter of section 230. 230 is such a wide provision. Rather, I should say we can even deliberate 230 section alone for 3 hours. I'm saying 230 of the Companies Act 2013. I'm not talking about IBC. I'm talking about under Companies Act, which talks about merger, amalgamation, demerger. We can really do wonders under section 230 by way of free section, because it provides enormous, it carries enormous provision. Now all process in place. Earlier there was no process, there's no separate rule process and all there. Now there's a separate rule. Amalgamation rules are there separately, and the process also there. The separate forms are introduced, and everything now specific. Earlier, most of things was at the court discretion, what to do, how to do, all that. Now almost that discussion is been reduced. Now more forms introduced in terms of merger, but still scope is more. What I'm trying to say, resolution plan itself has got lot of scope because it says anything provided to keep the corporator going concern can be given as a resolution plan. Now that also can be given in the form of merger and amalgamation, as I was telling after the amendment introduced in June 6, 2018. Now furthermore it got expanded now with sale or one or more assets also can be given by way of by one or more plans or by one or more applicants. That means the solution plan can be drafted, can be provided, of course, subject to compliance of section the provisions of IBC code and provisions of the Companies Act. If it is a merger among demerger, please make sure that also should be in compliance with the section 230 and read with the section 232 if it is an amalgamation. Okay, so we also keep it in mind all this thing. But if it is sale of one or more assets, it can be done pursuant to the provision of IBC because the IBC itself gives clarity on that. Same way, voting shares has been clarified whereby it says that member owned financial debt owned by corporate data to the members, owed by corporate data to the members of the committee who are eligible to vote. So only the members who are eligible to vote only will have a voting share. Now they brought much more clarity. Okay. Now going to next amendment. Now resolution plan definition has been very importantly. I show you this amendment. Now we are going to very important changes whereby section 7. What is that important changes? I already showed you, means I already deliberated on CARP regulations. What are the introduced? These are the why I touched upon CRP amendment also, third amendment, fourth amendment, because Amendment Act. Now the corresponding CRP amendment only I was deliberating in the start, just a while to you all. Then adjudicating authority shall within 14 days. What important change that we need to understand here. Now again they re-emphasizing, already it is there, but still again they are re-emphasizing that adjudication shall within 14 days. I will show you here the amendment. Okay. What it says again says very importantly, see in section 7, okay, in subsection the provision shall be omitted. There is no, I'll show you that. Then subsection following subsection shall be substituted. What is substituted? The following subsection 5 is substituted. That only I showed you that. Okay. The adjudicating authority shall within 14 days of receipt of by an order is substituted. Why they substituted? Again they re-emphasizing, saying that by an order, the AA should admit the application. Don't go into much of other things. That's what the law says here. The law says that admit the application if it is satisfied that a default has occurred. An application is complete and there's no disciplinary proceeding pending anything proposed RP. That's all. Or reject. Here, provided that before the AA shall, before rejecting the application, I'm talking about here, shall give notice to the applicant to rectify. That anyway they are giving, right? This is also provided that here this is very important. This only is a new provision. New changes have been brought in. Okay, rather I should say, I'll show it here. Provided that, so this only. Provided further that if the adjudicating authority means has not passed order within 14 days from date of receipt of application, it shall record the reason in writing. That means why they are not passing order within 14 days. They have to record the reasons actually. Earlier, that was not a prerogative of the adjudicating authority to record the reason. But law was it was insisting to pass an order. But now, in case they don't pass order, because they are seeing it takes time. Okay, at least give the reason. Well, that if it gets delayed. Okay. Now, for the purpose of this subsection, now again clarifatory amendment clarified where the requirement class A have been complied with, no other ground shall be considered to reject. So very important thing. Okay, and they should not uh, go into deep of other things when the requirement is they again it is kind of a what I said a clarificatory kind of amendment. Okay, said this only. I said, it shall record the reason for such delay in writing that where the requirement under class A being complied with, then no other ground. That means if everything is complied with, but what I was showing here, if it is complied, then don't see anything else. They are making it very, very clear and clean. Again, they are re-emphasizing, saying that by way of a clarification amendment, by way of introduction and explanation, it is clarified that where the requirement under class A has been complied with, no other ground shall be considered to reject an application. My God, it's a very strong word that we need to no other ground. That means just see whether A is complied with. That alone the law says today. That means if you are satisfied the default has occurred, the application is complete and there is no disciplinary proceeding pending against proposed. This alone you have to see. That means the law says, law makes it clear to the adjudicating authority that admit application if this condition is, and it also clarifies by way of amendment saying that for the purpose of this subsection, again it is clarified that where there is no requirement, that the requirement that class A have been complied with. That means once class A is complied with, don't go into anything. No other ground shall be considered to reject application. Let's wait and see how it goes going forward. Now, explanation 2, it is clarified that where the record of default in respect of validated vote recorded with infirmity, it has been furnished along with the application. That means recorded with information furnished along with the application. Such a record shall be considered as sufficient to ascertain existence of default. So don't go into deep of other parameter when there is oh, I think here, see. Such record shall be considered as sufficient for adjudicating authority to ascertain the existence of default. Then don't go into applying more, formulas, or don't go into applying more scenario or situation. Don't do anything when there is attachment showing that the whatever it attached, the record of default, okay, in respect of financial debt, recorded with information neutrality, that is sufficient, and don't go into deep. That's what the amendment says. Okay. Okay. Now, coming to next amendment. Same amendment only brought in other sections also. Same way, the other document. These are the proof only which I was narrating. I was saying that bank statements, all that I was narrating. So section 10, I was narrating what are the things to be attached to all that. So any other document, this only got amended by way of a third amendment in the CRP regulation. Additional document which has to be attached. Now again same thing. Shall record the reason for such a delay. Same thing what we deliberated in say 7. Same thing again. Now coming to next section. Okay. Now further the adjudicating has not passed an order. Same. Section 7, 9 and 10, same. If it is not passed within 14 days, the order is not passed within 14 days by AA, adjudicating authority, it shall record the reason for such delay in writing. That's all. They have to record the reason. Earlier that was not, there is no specification per se like that, but now they made it very specific that they have to record. Same way the record available in the information utility, if it is attached with the application, that has to be taken as the conclusive proof. Okay, now coming to 12A. See, 12A, I was also deliberated CRP regulation corresponding 12A in the beginning. Now what 12A says, again if you say, the adjudication shall pass an order within 30 days. It's very important. Earlier this is not there. This 30 days was not there. Now, if you see 12A has been after section 9, 10, 11, 12, 12A. Following section substituted. So a new 12A has been introduced. What is introduced? See, notwithstanding and any law in time being in force, an application admitted under section 7, 9 and 10 shall not be withdrawn before constitution of COC and after first invitation for submission of the resolution plan has been issued by the resolution professional. Okay. Now, adjudicating authority shall pass an order under subsection 1 within a period of 30 days. So the new requirement has been brought in under 12A. Now, coming to moratorium, there's changes in moratorium. I'll show you many amendment has come now in the moratorium provisions. In fact, moratorium, or rather I should say, is enlarged than earlier provisions of moratorium, which is now enlarged. Coming to the see. No. Okay, now, if you see section 14, I'll show you here. 14, then I'll move on to next. See. See, this only I'm saying. Okay. Okay, so here, section 14, the explanation has been for removal of, again there is a clarificatory amendment, whereby it is hereby clarified that the provision of subsection 1 shall also apply where the surety seeks to initiate or continue any action or proceeding against the CD pursuant to a contract or guarantee. So this is the new changes has been brought in moratorium. I'll tell you what are the again changes have been brought in. Okay. Now in liquidation, I'm saying the moratorium has been enlarged in the liquidation. I'm saying 33(5) has been enlarged in the moratorium. I'll show you that. Now appointment and tenure of IRP. Now the amendment says where the application for CRP is made, the RP has proposed the application shall be appointed as IRP if no dispute. So these are the changes which has been brought in now under section 3A has been brought in where application for CRP is made under section 10. Then AA shall make reference to the board for recommendation of IP who may act as a IRP. Now moving on to next important thing. Now we have to go into the important management of affairs. Not change here. Here same way. Here I was deliberating what is the claim portion. I will show you in the. I will show you. It means the corresponding thing only which I deliberated when I was talking about third amendment and fourth amendment. That's why I touched upon third amendment, fourth amendment, because when I show this, we'll have little clarity. Okay. Now this section 19 has been enlarged. The scope for personal. Now personal has become persons. Now earlier, if you see, it was personal. I should show you this. 19. Any person, okay? The amendment now says person to extend. How it was earlier? I'll show you the code earlier. Before amendment, then only you will understand how it applies. Before. This is before amendment, okay? So if you understand, then easily you can relate to amendment. See, this was the heading earlier. Okay? Personal to extend cooperation to IRP. Now see what is the heading? Person to extend cooperation. Now this is the, okay? Person. Why it is now? Because it enlarged the scope to now. Earlier, it is personal. The moment you say personal, it restricted to the corporate data. That's why it says personal of the corporate data. So no outsiders can come. Okay. Now, if you see the language, any person who is or who has been personal of corporate data with the management or engaged in a contract for service. Very important. Now, any person who comes in contract also covered now. It's a very important amendment. Now, earlier you see promoter, person associated with the management, that's all. It only earlier talking about person, promoter, and any person associated with the management. Then, where any personal of the corporate data, it's promoter. That's all. It was restricted only to promoter and personal of the corporate data. Now, if you see the scope, it enlarged. Even the service provider also means any contract of service is availed. They are also supposed to cooperate. That means if any service is availed by the company, okay, it can be anything. And they also now supposed to listen, not only the personnel of the company. So this changes and all is really a welcoming changes, and that gives more, what to say, liberty to, IP and RP to see that CRP is really done effectively. Otherwise, outside people will say that why I have to answer to you. I need not to answer. It is done only to the company. Now why I have to answer? Okay. Okay. So now the personnel has become persons. And now contract of service also is included. So now it is got expanded. So now we can also take details from or make a person who has rendered service to the corporate data by contract of service also to give support. Very important now. Okay. So direct such a person is referred in subsection 1, same thing. Same way any person referred to subsection 1 does not assist, then make an application. Even the person who is rendered a service by a contract, if he is not providing any support, extend his assistant, then also application can be moved against the person. Okay. See, that is the reason they changed the word personal to persons. That means any person, need not to be a person employed in the company, ex-employed, any person outside the company who rendered service to the company. Now also is included. Okay. Now, of course, they included the RP into the IRP definition. So whatever provided here, now RP also shall have a same privilege. Now we are coming to the main part. Okay. What I would say, this is the committee of creditor who has become superheroes in liquidation. Okay. CRP, they were already superheroes. Now in liquidation, they become superheroes. Okay. I think after the break, we will 10 minutes. By then, If anything you want to share, you can read the provision and you can share. Anyway, I'll share my view on that. I also thought I can take your views also, so that amendment, how really it works, or what is the intention of the regulator. Let's all try to understand. Okay. We all again will discuss after break. I'll come back in 10 minutes. Okay. Okay, shall we start again? I'll again share my screen. Yeah, we were discussing this earlier. Okay. Now coming to important aspects of the Committee of Creditors, Section 21, what it is amended. Now let's really see the provisions now. Okay. Now it is amended that where liquidation process of regulation 11, okay, sorry, subsection 11, where I will take you to amendment. Yeah. See? Yeah. Now let's see what is section 21 in the principle. After 10, following is inserted. So that means this is a new provision which has been inserted. The entire section, subsection 11 has been inserted. Okay, now let's discuss what is section 11 inserted. Okay, it is inserted in the COC provision. Committee of Creditors, section 21. We all know this. This is the existing provision of section 21, which talks about how the claim has to be collated and how the Committee of Creditors shall be constituted. All that is there. Okay. Now, in section 21, subsection 11 has been introduced, has been inserted, whereby where the liquidation process of CD is initiated under Chapter 3, the COC constituted under this section shall also supervise the conduct of the liquidation process by the liquidator, and the provision of this section and section 24 shall apply to such liquidation provision. What is the section 24? Shall we see section 24? Okay. Section 24 talks about meeting. Why I am showing this? Because they are telling both shall be applicable. So that means the meeting of creditor and section 21. This both they are referring. Okay. 24 is that the provisions of this section and 24. Okay. Provisions of this section and section 24 shall apply to such liquidation process under Chapter 3 as the context may require. We need to understand what is that as the context may require. Here also we need to understand. Okay, let's deliberate what is the context. Provided that board may specify any other class or class of creditors who may attend the meeting of the committee of creditors during liquidation process but shall not have right to vote. So board has to specify who else can attend other classes. Okay. Expression for the purpose of this chapter 3, it is hereby declared that the provision of subsection 11 of this section and section 34A and subsection 2 of section 35 as amended shall apply to what is section 34A? 34A, shall we see? In the Amendment Act, we see. What is that 34? 34A. 34. Okay. Because it says 34A. 34A is this. Where at any time during the committee of the opinion that the liquidator appointed in section 34 or this section is required to be replaced. Replacement provision. Okay. where the committee of creditor resolve that under subsection 1 to replace the liquidator, it shall apply to AA for appointment of. Okay. So here it talks about, okay, talks about subsection. It is hereby declared provisions of section 11, okay, of this section, section 34A, which I showed you, subsection 2 of 35. What is that subsection 2? 2 of 35. Shall we see that? Subsection 2 of 35, because it's a new provision. Okay. See? So here it says subsection 2 of 35, where it talks about consultation, all that, right? Okay. Mm. Mm. This is the subsection 2. What it says, subsection 2, section 35, what it is? It's the powers of liquidator. You must be knowing all that, right? Everybody must be knowing it, or you want me to show what is 35? It's powers of liquidator, 35. Okay. So in that, earlier it used to say that consultation means it is not binding liquidator, any consultation with the SEC. It's not binding. So now they changed. Okay. I will show it lesser font. Okay. See? 35. Powers and duties of liquidator. That subsection 2, liquidator shall have power to consult any of the stakeholder entitled to distribution of proceeds under section 53. Further, that any such consultation shall not be binding on the liquidator. That means he can consult any stakeholder, but that is not binding. Okay. Now it is now changed. How it is changed? Now, instead of that provision, this following subsection is introduced. So now we are from the regime of not binding, decision of SEC is not binding liquidator. Now completely the liquidator under the supervision of the committee. So from that regime to this regime, but in such manner as may be specified, and also as the context may require, which we have seen in 21. Okay. It is not that simply we can. Yeah. Now I will take you to our amendment. Okay. Now I showed you section 34A. It talks about replacement of the liquidator. And I showed you subsection 235, which talks about the committee of creditor. That means the liquidator shall act on the supervision of the committee of creditor shall supervise the liquidation process. Okay. Now, but before that it says the provisions of this section and 24 shall apply to such liquidation process under chapter 3 as a context may require. Okay, if the context occurs, we have to see which context they are talking about. And the provision of the subsection 11 of the section, for the purpose of this chapter 3, it is hereby declared the provision of subsection 11 of the section and 34A as amended by Amendment Act shall apply to liquidation process of CD initiated after commencement. A shall apply to A, liquidation process of corporate debtor initiated after the date of commencement of Insolvency and Bankruptcy Code Amendment Regulation 2026 and the ongoing liquidation process and of the corporate debtor as on date of such commencement where the liquidator has not made an application under section 54 for which the committee of creditor shall continue for the remainder of the liquidation process. Now we need to understand that the word shall continue is how it should be understood. Shall continue means the COC should exist, or they say by virtue of this provision their existence is automatic. I don't. I'm just asking your opinion on that, views on that, because this is new amendment. That's why while starting the session, I said it's not a settled, today it is not settled one, like IBC code, last 8 years we are into that, practicing into that. But now its amendment is new, 2 months old. So we have to wait and see how the meaning is coming out, or how in everybody perception, how it is understandable, and how you understand. And I think if you can share your views, probably we can deliberate. And is it applicable to? I'll put my questions. Is it applicable to all liquidation? That is one question. Or it is applicable to class A liquidation process, which it satisfied, means it. The first category is that we need to deliberate and understand whether this particular provision is applicable to all liquidation process. All. They can simply put all, but they have a certain reason. That's why they are putting this kind of thing. Otherwise, they can put all liquidation process, whether existing or future, they can put. But they have not put that. Okay. They are giving a bifurcation and say context as may require or shall apply to, and then they use the and between A and B. Okay, liquidation process of copyright initiated after. So that means let's have a three category. One is whether is it applicable to this provision applicable to all liquidation process, whether it is old or ongoing or future liquidation process. It means liquidation process commenced on or after amendment, or it is applicable to ongoing liquidation process. So is it applicable to all? First point. Second point, it is applicable to the liquidation process which is satisfied both A and B condition. Whether it is possible or not, that interpretation is different. Both is possible or not. But since and is used, whether is it the prerequisite that both A and B has to be satisfied?
Yeah,
To
both have to be satisfied.
no, wait. That's what. I'm in two now. Okay, whether it both has to be satisfied. Two,
Yes.
three. There's the third scenario. Why I'm telling third scenario is also important, which if the provisions are silent, I don't know. There's no deliberation on that point. That's why I'm bringing this scenario. The third scenario is that there is a SEC. There is a SEC. There is a SEC. 31A. Now it is omitted today. Because why I'm saying this, SEC we all understood is nothing but a different form of COC. Because
Correct.
during CRP, there's a COC. During liquidation, the regulation has been amended to introduce class 31, regulation 31A, whereby SEC came into existence with effect from 25th July 2019. Correct? 25th July 2019. So SEC was there. Today, after this amendment came into effect, the SEC is omitted. So today there is no SEC. So is this applicable only to the cases where SEC was there? Because there are cases where the liquidation process commenced before 25th July 2019. The SEC was not applicable to them. So there was neither COC nor SEC to those liquidation process. So that means that there exists no COC, there exists no SEC. Then the question of continue, how it comes. So there's a three scenario. Scenario one, is it applicable to all liquidation? Scenario two, whether both A and B has to be satisfied to say that it is applicable to that liquidation process. Three, there should be SEC to that cases. This particular provision is applicable because it uses the word continue. That only bringing the confusion here. And also here it says as the context may require also is important to understand. So I think you can share your input. We'll all discuss and we'll exchange our views on this. Yes, sir. You please carry on, sir. Now you can share your views.
No, sir. Yes, I did mention it has to satisfy both the conditions, but like you rightly mentioned and highlighted, that so it has to include both, but excluding wherein the COC has already been instituted uh, earlier, and prior to 2019, that I'm not sure of, sir. So I'll be very candid about it.
No, there are 19 participants, I think. 19 participants. I think many must be handling liquidation process. I think you can share your views because this is a platform where we can exchange our views. This is the right platform where we can exchange so that it reaches the regulator, whatever we share our views. Any other views? That's all. Out of 18, only one views. Only one. There is no other view. No, either one situation you can tell no. Either you must be clear or you should not, you may not be clear. Either way you can tell me what it is. If you are clear, you
The more I'm
yeah.
the more I'm reading, the more confused I get now.
Sorry?
With regard, the more I read,
Uh,
the more confusion it creates.
I'm asking other friends, no other IP friends who are there in the, because very important provision. This only literally changes the entire thing. I told you, no? Right. The superhero is introduced, right? Who was not there in the picture called liquidation. Suddenly, not even a hero. Now, the earlier, probably we can say, like Bahubali 1 and 2, like that we can say that 1 is a CRP, 2 is a liquidation. The hero of Bahubali 1 suddenly has become superhero in Bahubali 2, like that. Suddenly, but that word continue is there. Here alone, it brings a confusion. Continue means what? That should exist. Something should exist. Then only it continue. Right? But the moment we pass, liquidation order is passed under section 33. There is no concept of committee of creditors. That means legally it vanishes. Existence vanishes. Then what it says continue, that means how it continue legally. Is it right that to say that they are continuing? Probably okay. If the lawmaker says or the regulator says yes, they are continuing, okay. But is it correct that who are not there legally existent in existence today, how they can continue? They can be again be constituted. Whether continue is right. If it is again to be constituted, then okay, because they were not there earlier. Legally, they are vanished. Because the constitution word is not used. I think our friends should say something. Otherwise, I will leave this open, this point, then I will move on to next one there. I'll leave to your views. Because you are, at least I should get 3-4 views, no, out of the 17 or 18. So what do you feel? It is applicable to all liquidation process. We can have any understanding of that, nothing wrong in that. If we can express our views, then probably that can give more clarity to institute or if it is clear, we at least you can say it is clear. We'll move on to next one. If you ask me what you are saying, that I say a little confusing, as our friend said, little confusing only, because I showed you here as the context may require and provision of section 11 of this section. Adding, I think our friends are silent, but anyway, that's what I will deliberate. I will move on because end of the day, you are only going to handle the liquidation process. Your liquidation process, I'm not going to handle. You are only going to my liquidation process, I'm going to handle. So let's go with our own views. That's different. But at least we are getting an opportunity here to deliberate. Okay, and share our views. Otherwise, then you go with your whatever your understanding. But here I'm also getting confused, like our friend shared. Furthermore, to my confusion, and this also adds furthermore add my points to my confusion. I'll show you here. Liquidation regulation. Yeah, this regulation which has been amended. So everybody is silent. Let's be silent. Let everybody follow. Then we will also follow. Why to come out? No, it won't happen that way. If we come out only, things will change. Otherwise, we'll end up with complications only. Better to come out now itself and deliberate and understand, give our inputs to ensure what exactly it is. Keep silent, okay, enjoy your silent and complications also enjoy. See, I wanted to show one important position. That's why I'm showing. Now, adding confusion, which I told you, okay, here, coming to regulation 8. Yeah. This is the new provision which has been introduced. Okay, under IBBA regulation. If you want to show me the regulation also, I will show the regulation. It's a new regulation. Okay. This is a new regulation. Okay. This is a new regulation, Committee of Creditor. The amended regulation I have showed you. This is the amended regulation, the Committee of Creditor, which only I showed you here. Okay. Okay. Now here what I was sharing section 21. Here furthermore why I said I too little get confused because of this proviso. See the proviso here. Here they say the provisions of regulation 18 to 26. 18 to 26. Chapter 6 and 7 of the insolvency corporate person shall apply mutatis to meetings of the committee. Here shall apply to mutatis to the committee, meeting of the committee under liquidation proceeding. So that means as it applicable, that means mutatis. Okay, however it applies. Okay. Okay, fine. Now coming to the proviso, provided that the first meeting of the committee shall be convened within 7 days of liquidation commencement date. Then this leave us with a conclusion now, like how in the beginning our friend was saying, both the condition has to be satisfied. Then only it is applicable. Because this can be made applicable to new cases, then only they can convene the first meeting of the committee within 7 days of the liquidation commencement date. Because this is the new provision inserted in the regulation. It is not earlier one, where I can say that, okay, already this provision is there. So what is there? It is applicable to earlier cases. If it is already existing in the liquidation regulation, it's fine. We can understand that way. But this particular regulation itself is inserted now only, completely replaced, substituted. Now, a new provision corresponding to the amendment in section 21 of the amendment. But that new provision, how it can sound that it is applicable, we convened within 7 days from the liquidation commencement date. You have any views to share here? You can share. Otherwise, I'll move on to next point on amendment. Okay. So this both reading jointly gives confusion only. That to whom it is applicable, whether all liquidation cases or cases which satisfy both the condition A and B, or the cases where since SEC provision 31A is omitted now, since it is omitted, SEC is there, already is there, so it is omitted now. Those who have already constituted SEC and convened a meeting and taking inputs and advice of SEC, now no longer, SEC is no longer, then they're supposed to have COC. Is that understanding? Then what happened to the cases where there's no SEC? So all these questions are open now.
Sir, had it been instead of and, they had just or. It's
Or means they're clear.
Then it would have been
clear,
right? So and is maybe a I don't
Or
know.
means there's nothing to discuss.
Correct. Yeah.
There's nothing to discuss. Okay. So that's why the whole confusion arises here. And along with that regulation proviso also. That regulation. If we read jointly this subsection 11 of section 21 with this regulation 8 which I showed you, regulation 8 of the amended thing, proviso to regulation 8, subsection 2 of proviso to subsection 2 of regulation 8 of the amended liquidation regulation, that gives more confusion. So that's the reason I was telling you that I'm also not able to come to a conclusion. Because if I come to some conclusion, if somebody raises a point showing this, then I have no answer. Okay. So I will keep this point open to all 18, 16 members, I think online now. Friends. So I think they have to interpret it in their own way and move on because of this confusion I'm saying. Okay. Because you are not deliberating. If you are deliberating, I can come to the conclusion or form some opinion. If you are deliberating, if everyone deliberates, we can form one opinion and we can share our views to institute also, regulator also. If you keep quiet, then I have to leave it to you only to decide. Okay, fine. Now going to next amendment. Okay, the appointment of resolution profession. Now coming to section 22. What is that new amendment? Where COC resolves to continue the IRP as RP, subject to recent conditions, such person will be deemed to be appointed as RP from the date of such resolution, and this decision shall be communicated to IRP and board. So this is now a new provision has been introduced, okay, where the committee resolves under subsection 2 by way of a 66 majority for appointment of RP, then they have to intimate the IRP. Okay. So that now a new requirement has been brought in. Okay. That they have to communicate. Okay. Now going to next provision. Yeah. Now, very importantly here to see in duties of resolution professional. Okay. In that the duties are given like what section 166 of the Companies Act where duties of directors prescribed under section 166. Similar way, duties of resolution profession given in section 25 of IBC. Okay, that duties now they introduce the class J, whereby filing an application to adjudicating authority in respect of avoidance transaction and fraudulent and wrongful trading also is one of the duty today. You can't fail. Okay. Now coming to next right and duties, and then now coming to very important application in respect of certain transaction or trading to affect. Now the filing of application in respect of avoidance transaction under section 47 shall not affect the proceeding of CRP or liquidation process. They are making it very clear. Just filing of application with respect to avoidance or fraudulent and wrongdoing should not affect the CRP process or liquidation process. And I will also show you one more provision. When I take you to section 54, I will tell you. There is a provision enabling this. Okay. When I take you to 54, I will show you. For removal of doubt, they also said it is hereby clarified completion of CRP or liquidation process shall not affect the continuation of the proceeding in respect of avoidance. That means completion of CRP and liquidation process will no way affect continuation of proceeding. Why? Because this can be continued by COC. That's what the provision of 64, new amended section 54 says. I'll show you that. Next time I'm taking it to you. Okay. Now, coming to this is a early old provision because you must be by now by heart with these provisions. Now, this is a amendment, third amendment. Third amendment of CRP regulation when I was deliberating in the beginning of session. This only I was referring section 28A of the new insertion. There's a corresponding regulation I was discussing with you in the beginning of my session, whereby it enables today, notwithstanding anything in this code or any other law type time, where a creditor of the corporate debtor has taken a possession of an asset of a personal guarantor, very important, or corporate debtor, both are important. Okay, proper possession of the asset of a personal guarantor or corporate debtor. Who? It is a creditor. Creditor, okay? Where a creditor, please use, see the language here, where a creditor of a corporate debtor, it not uses any other word, just creditor. Where a creditor of a corporate debtor has taken possession of an asset of personal guarantor, corporate debtor of the corporate debtor by enforcing its security interest. That means security interest means then we should we have to read creditor with the security interest over such asset under any law for time being force which empowers the creditor, again creditor, to transfer the asset. The creditor may during CRP, very important, only during CRP, okay, permit transfer of such an asset as part of insolvency resolution, okay, with the prayer of COC in such manner subject to provided that where corporate debtor is undergoing a CRP or liquidation process. Here if you see the liquidation process also has come. There, see there it was referring CRP process. Why? Notwithstanding anything contained any law where a creditor of has taken possession a corporate debtor by enforcing security interest over such asset under any law for time being force. The any law may be such for or any other law, okay, which impose creditor to transfer the asset. The creditor may during corporate insolvency resolution provision of the corporate debtor permits the transfer of such an assets as part of the insolvency. Here, a provision is introduced whereby where the corporate guarantor, not the personal guarantor, then that means only for the personal guarantor they are restricting this. Okay. In case of corporate guarantor, then even during liquidation process they are bringing. That's what it sounds, it appears. Okay. Further that where the corporate guarantor is undergoing CRP process, here what is applicable in CRP. Okay. Now in liquidation process also here it is okay. That means since it is a corporate guarantor. The difference here is corporate guarantor. Okay. This sounds this way. Okay. As part of insolvency process. So liquidation process also, during the liquidation process, transfer of assets under this subsection shall take place upon approval of COC by FCC percentage and amount received pursuant to the transfer. Amount received pursuant to the transfer shall form part of CRP process. Also the liquidation estate. See, that means even during liquidation, this request can be placed before COC and COC we can consider. Okay. So further, during the liquidation process of the corporate debtor, okay, during the liquidation process of the corporate debtor, approval of COC and the first position is required only where creditor has relinquished such asset to the liquidation estate. Otherwise, they need not to take. That's what it sounds. Provided also the personal guarantor, it's of course, it again goes on to say that provided also that when the personal guarantor is undergoing CRP, a bankruptcy person has forfeited surrender its rights all that is the personal guarantor. Transfer asset pursuant to subsection 1 under resolution plan shall vest, very important, shall vest in the transferee all rights, and so there need not to be any documents on this. It automatically vests. Okay. Under resolution, if it is forming part of resolution plan. Okay. And the amount received pursuant to the transfer of asset shall be adjusted towards debt owed by guarantor. It's very important. More owed by guarantor. Okay. These are the important catchwords that we have to say. Okay. Okay. If the amount is excess, it has to be returned back to the guarantor. That's what the amount. So coming to the next amendment. No, I'll take you to where it's an important aspect of this. These are the earlier amendment, and now this is introduced now. What is that? Under insurance, under chapter 2, under section 30, submission of resolution plan. Now additionally, now what the provision says that it can provide for payment of debts or the financial creditor who do not vote in favor of resolution plan in such manner as may be prepared, shall not be lesser than the lower of what? To be paid, amount to be paid to such creditor in the event of liquidation of corporator under section 53. This is in the waterfall mechanism, that's 53. Or, see here, or is there. That would have been paid to such creditors if the amount would be distributed under resolution plan had been distributed in accordance with the order of priority under 53. So additionally they can. For the purpose of this section, it is hereby declared the provisions of this subsection as amended by Amendment Act 2023 shall not apply to CRP where any of the following acts have first occurred. What is that? The committee of creditors has approved already the plan. Adjudicator has passed a liquidation order under section 33. And 3, the committee of creditors approved intimation to adjudicator to initiate, then it is not applicable. So they are very clear. In these cases, they can't bring it retrospectively. Okay. So it can also provide implementation supervision of resolution plan and constitution of committee for the purpose of consisting RP, and that also now can be provided. Okay, earlier this was not part of the, now it can be provided. Okay, it's a very important change. Now coming to another important changes. Approval of plan. What is that approval of plan? So now, earlier the provision, now the provision has been inserted whereby provided further the AA may on application made by RP with approval of COC by 66. Okay. First approve the manner of distribution. 2 stages is brought in today. Earlier under section 31, the approval either the resolution plan is get approved, gets rejected in one go, in one time. That's all. But now the provisions enabled whereby it gives liberty to the adjudicating authority. First approve implementation of plan. Then thereafter approve the manner of distribution provided within a period of 30 days from the date of approval of implementation of such resolution plan. Okay. That means within 30 days they have to approve. Okay. First approval. So that means there can be 2 different approval for resolution plan. First, to approve implementation of plan. Second, distribution. Okay. First is the implementation. Second is distribution. Okay, 2 stages that can be an approval. Provided AA may, before rejecting plan, they can give notice to the committee of creditors to rectify if any defects in the this additional provision now given. AA shall pass an order and substitution within period of 30 days. Now, within 30 days, they have to pass. Otherwise, what will happen? As usual, they have to record the reason, which you have seen in section 7, 9, 10. Same thing here. Okay. Now, again, subsection 5, what it says? Not to say anything contained in any other where a plan has been approved under subsection 1, a license permit, all that is, shall not be suspended, terminated. Person who this additional privilege today given in the while approving the plan. While AA approves the plan under subsection 1, now unless other that any claim against the CD is assets under any law for time prior to that shall be extinguished. So these and all they can provide. No proceeding shall be continued uninstituted. And for the purpose of the section, it is clarified that nothing in the section shall affect claim proceeding in respect of a person who was a promoter, management office, guarantor having this exclusion they are giving. Okay. For the purpose, it is hereby again clarified. If a person has a joint liability, all this exclusion, joint liability. And again, there's a removal of doubts. It is hereby clarified. Subsequent 5, 6 shall be deemed to apply to the business plan that is approved and subsequent from date of commencement of this code, except for the matters that have attained finality under this code. They use very carefully the word. If something is attained finality, then that cannot be implemented to the. That's the reason they don't want to apply it. Okay. Now I think 32A, all that we know already. Now coming to initiation of liquidation. Very importantly, now if we see initiation of liquidation, subject to regulation 52, now declaration of moratorium has been introduced for the purpose of class A and C of subsection 1 in subsection 3 of section 14, which I showed you in the moratorium class, which shall mutatis shall apply to. That's why when I was showing section 14, I was telling you that this is extended to liquidation proceeding. So it shall apply to mutatis to liquidation proceeding under chapter 3, whereas the provision shall not apply to liquidation proceeding in relation to okay. Person order upon a liquidator. So now the moratorium of section 14 stand extended to liquidation process also. And again, notwithstanding anything under subsection, where AA has grown mentions that it shall before passing liquidation order consider an application made by EC, COC, not less than restoring the CRP. That means after even filing the CRP, I mean application for this liquidation, if COC by way of a resolution, I mean voting by 66%, if they resolve for restoring the CRP, then it can be considered by AA. If we satisfy that there exists a condition before passing liquidation order. This is very important. This is the criteria. Before passing liquidation order is a criteria. So before passing liquidation order, the CRP can be restored. Again, giving a life, getting a second life. CRP, second round. We can say second round of CRP. Okay. If the ground mentioned in class A can be exist, restore the CRP to be completed. Here only thing is 120 days alone is given. Okay. And restore the CRP to the stage of, if the ground mentioned exists, then restore the CRP to the stage of invitation of the resolution plan. That's all. Only to that stage they will bring. Okay. They will see the stage and accordingly they pass on. So therefore, restoring the CRP also now introduced. Enough liberty is given today. Okay. They can do CRP, try to liquidate, dissolve, or they can rebring the CRP. Okay, what not. But only thing is, CRP of course will maybe restored only once. This is the only condition today. You can't keep on restored. Okay, only once only chance is given. You have to try to do that, or you have to go into file a liquidation. That's all. So now, in addition to the word, even during the liquidation, taking a decision for liquidation, dissolution itself can be considered. That's what the word dissolution is introduced today. No? During liquidation, even dissolution can be considered. Okay. Provided the COC shall, before taking a decision to dissolve, comply what are the conditions as per the regulation. Yeah, here again, AA shall pass liquidation order within 30 days. Now again 30 days timeline has been brought in or record the reason. Okay. Whether that were subsection application made is the CRP pass. Okay. Is made all that is there. Where a liquidation order has been passed, again subsection 6 has been used. No suit or legal proceeding shall be commenced, or if pending at the date of liquidation order shall be proceeded with the liquidator. Why this amendment is there? Why this amendment is there? Earlier what it says? Earlier what it says? Earlier what it says? See? When liquidation order has been passed, no suit or legal proceeding shall be instituted. The word instituted. Okay. Earlier word was instituted. Now what is that? Earlier shall not be instituted. Now here no suit shall be instituted and no suit other shall be instituted, or if pending at the date of liquidation shall be proceeded by the liquidator. That means whatever is applicable during the CRP, same is now extended to the liquidation process also. Okay. Now this is a very important change. So we need to understand. Now coming to the another important appointment of liquidator and fee to be paid. Where AA passed an order for liquidation or for corporate debtor under section 33, it shall refer to the board for making recommendation of the insolvency professional. This is the amendment again. Section 34. Appointment of liquidator and fee to be paid. Okay. Now this is a new introduction. Now where AA passes an order for liquidation of under 33, it has to refer. Okay. Now again, any person, whatever we have seen section 19 during CRP, now stand applicable during liquidation. So a provision has been introduced under section 34 that any person, no personal here, person who has been a personal of corporate or engaged in contract service shall extend all assistance, cooperation to the liquidator as may be required for the purpose of managing affairs or performing the duties conferred on him under this chapter. Provisions of section 19 shall apply. Specifically they put, and additionally they elaborated also and also said it stand extended. Okay. Now it is much more clarity is given. That means now whatever the support that RP can expect during CERP, a liquidator expect the same support assistance during liquidation. So there is not much change between CRP and liquidation. Okay, that's all. So now let's move on to 34A. 34A is replacement of liquidator by COC. Now power is given to COC to replace. Just throw and appoint somebody else. Okay. Where at any time during the liquidation, if the opinion, the section is required to be replaced, it may by vote of 66%, they can replace. Where COC resolves to replace, it shall apply to AA for the appointment of proposed liquidator and no by an order replace the liquidator appointed. Okay. Now this is a provision. Now, okay. Now again, power of liquidator. Now very importantly, The power is now inserted to maintain an updated list of claims of creditor in such manner as may be specified. It is only to maintain. That means now the adjudication powers is now restricted to liquidator. They have to maintain because they have to liquidator after the commencement of liquidation, after this position, they have to only see that what are the claims given. It is there in the regulation. I'll show you the regulation. Continue or institute the claim in respect of there's a new provision introduced in L in respect of an avoidant transaction and fraudulent. Here, importantly, this provision has been used, which I showed you earlier. COC shall supervise the conduct of liquidation process by the liquidation under Chapter 3 in such manner as may be specified. Okay. So now entire control is given to COC, but which liquidation process only? Now I was deliberating with you and the clarification I think is expected from you because you are not opening, then how a regulatory will come out unless you deliberate. Okay, so now coming to taking to very importantly 47. Now they introduced 47 whereby they said that where professional transaction underworld and fraudulent has occurred and liquidator RP not reported, then the creditor or jointly they can make an application to AA and pass an order. In which case the RP will face the consequences. RP or liquidator will face it. What they have to say, they'll be replaced only. That will be the consequence. Okay. Okay. Now coming to same thing prior to 2 years initiation date. I was showing the definition of initiation date for that. Okay. Now very importantly, coming to this important this thing that secured relinquishment. Okay, 52. Now they are given a period of within 14 days from date of liquidation. The secured creditor whoever intends to realize, they shall inform the liquidator and identify the asset subject to security to be realized within within a period of 14 days from date of liquidation commencement date. Okay, this is very important amendment. Now again an important change has been brought in where the amount of insolvency process cost, whatever that it has to be escom shall be deducted from the process. So that naturally should happen. Now coming to distribution, very important. For removal of doubt, it is hereby clarified where the value of security is relinquished by the creditor is less than the total debt owed to such the creditor, then he shall be a secured creditor only to the extent of the value of such wherever the relinquishment has been provided. That's all. It is restricted to that. They are making it very clear now. Then and what happened determine such manner, and for the remaining value of such debt, he shall be considered to be an unsecured creditor. They are making it very clear. Okay. Okay. So this is only say for the removal of debt, it is clarified that any amount, whether or not security interest created or when act more or part by operational law due to security the central government or state government in respect of whole or any part of a period of 2 years preceding liquidity company shall be distributed under subscription, and remaining amount, whether or not such a security is created to secure shall be distributed F class F. Last. Now coming to very important 54 dissolution, whereby a new section has been introduced that you have to carefully read and understand. What is that new provision? Dissolution of corporate data, a new section has been introduced. It says the liquidator shall completely liquidate the asset, make an application for its dissolution within a period of 180 days from date. That means liquidator himself shall make an application. Okay, there's one point here. Okay, himself can make an application. Further, the adjudicator may on sufficient ground extend the period. But a proceeding in respect of and avoidant transaction problems section is pending before application is made under this section, or a decision is made to dissolve corporate. Here only the decision of COC is coming in place. Here, liquidator himself can do. Here, decision is made to dissolve. So, even if liquidator files on his own, so whatever the application is pending and subscription, then that has to be considered as provided below. Okay, our decision is made to dissolve a corporate debtor. Then also means the decision is made to dissolve the corporate debtor by COC. Shall determine the COC. In both the scenario, the COC shall determine the manner of pursuing such distribution. That's the reason we have seen the provision earlier that the closure of CRP or liquidation process will not affect the proceeding initiated under section 47, 49, 50 and 53, all that we have seen that, 66, all that we have seen. Why it is not affecting? Because now COC is given the responsibility of taking care. The shall, it is not a kind of a thing. They shall determine. COC shall determine the manner how it should be dealt with. Irrespective of liquidation there or closed, they shall. Okay? Means they have to take a decision how it should be dealt with. And any suit or proceeding against the corporate debtor in respect of any, not only this avoidance transaction, also any other suit pending before application is made under, or a decision is. See here, if you see any suit proceeding in respect of the process is pending before application made under subsection 1, that means made by liquidator. This is application made by liquidator. Here, if the committee resolved to make and dissolve the company, the committee shall make, in both the scenario, the committee shall make appropriate amendment for pursuing that suit, whether application is made by liquidator or if the committee resolves to make application for dissolution. This is a very important thing that we need to understand. So let us not too much think about avoidance transaction is there and pending suit is there, how to file dissolution, all that. Now answer is there today under amended section 54. Okay. Now I'll take you through to regulation. See, regulation, as I was telling, committee means committee of creditor constituted under 21. They are not saying regular. There is no section introduced during liquidation or regulation introduced during liquidation, constituted under CR. Contribution to liquidation cost, they said liquidator may call upon the members of COC contribute excess of the liquidation cost over the liquidation cost as estimated by it. Okay, so they can. But no compromise, that cannot be, shall be filed unless such compromise has been approved with the requisite majority. Otherwise, this cannot be filed by the liquidator. This is a new provision has been introduced. Recommendation of liquidator by committee. This also we have seen already. Enabling provision is given, so recommendation can be come. Main responsibility from the panel of the insolvency profession prepared by the board that way. And now new table has been introduced, and the committee may fix in the first meeting or it will go by the schedule. Okay. Importantly, here it is not applicable. It is applicable prospectively. It is very important to note. It is applicable prospectively. Okay. It's a process commencing on or after 4th amendment of the liquidation. Very important. Now the reporting, liquidation shall prepare progress report, final report, dissolution in a manner that IBBS came with the new circular, all that they came with new circular. Now appointment of professional can happen with approval of committee if constituted. This I already discussed. Committee of creditor, they whoever constituted under 21 shall continue to function and the same provision whatever they included. And provision of section 18 to 26 of CRP regulation shall mutatis mutatis shall be applicable. And here I raise the point, committee shall convene within 17 days. I don't know if it is applicable to old cases. It cannot be complied with. Can't be exception also. These are the power that the committee, the liquidator shall not undertake the power given to COC today, that with their approval only, the liquidator shall exercise the power. Continuing suit, all that is there, even to make sale, all that is given, wrongful trading, all that is given. The new subsection 8, patiently we have to read and understand. Facilitation of transfer of asset, which I told you during the liquidation process also how it should be done, which we have seen in the Amendment Act, what we have seen. Same thing. Now preliminary report, all that. Now agenda has to be in this regard should be placed. That's our new requirement has been introduced. He shall prepare. That means before running, if it appears to liquidator that he shall prepare an agenda on this regard and prepare board, and that if it decides by the voting shares not reasonable, the for early decision he shall apply. Now it has to be placed before COC. Okay. Okay. Now to see importantly that very importantly, board has you all know that board has notified the format of circular. Okay. I can show you the circular also. Relinquishment within 14 days, which is there in the section itself. Not a new one. Verification of claim now has been amended. There's section 42, all that is removed, giving power to liquidator to adjudicate the claim, all that is removed. Now instead, verification alone the liquidator can do now. Okay. So these are the provisions where verification alone can be done by liquidator. So liquidator no longer can adjudicate the claim. He has to make sure that what are the claim admitted in the claim. During CRP, he take on record and update the claim only. It says, I showed you maintain an update in section 35. It has been introduced. So mode of say now has been introduced whereby with the approval of COC only all this can happen. Okay. Now with the COC, very simple. Before many provision, the subject to approval of COC has been introduced. So that it makes very simple to understand. Now take approval from COC for anything you want to do. What are the amendment introduced? So that now liquidator is not independent anymore. He is only subject to the supervision. To whom it is applicable only, I think we have to get a clarity on that. If you are clear, you can follow it. Probably to my limited this thing, I little get confused on that. Okay. So liquidator shall continue to discharge his responsibility on liquidator till the application for extension is decided. One more rider is given. Since the extension application is there, sometimes liquidator get confused at what to do. So till extension is decided, liquidator shall continue to discharge the responsibilities. So important rider has been given, and he shall submit the final report and file dissolution application. All that is there. This is about corporate liquidation account. Same thing, not much change. So any doubt you can ask me both in the Liquidation Amendment Act and Amendment Regulation with respect to liquidation regulation. Because there is no much deliberation, so I didn't have a much scope to deliberate more. Because when something comes only, I can deliberate. I can't see the video on my own, I can't deliberate. If any doubts, you can share.
It's been exhaustive, sir. So maybe that's why. Too overwhelming as of now. Yeah.
No, what I understood, I just shared. That's all. What I could not understand, I shared that also.
Correct.
Madam, shall we close the session, ma'am?
Sure, sir. If there are no questions, then we can close the session. Participants, if you have any questions, then please ask.
Okay, thank you all for your patient hearing. See you again.
Thank you, sir. Thank
Thank
you
you very much, sir, for
Thank
giving your valuable time and
Thank you, ma'am.
sharing
Thanks
your
for the
thoughts
opportunity.
about the topic.
Thanks for the opportunity. Thank you.
Sir, please share the presentation of the session, please.
He's left.